Okay, the next case is Hernando County, Florida versus Hernando County Fair Association Incorporated. Okay, counsel for the appellant, I'm assuming 5 minutes for rebuttal unless you tell me differently. Is that okay?
5 minutes for rebuttal.
All right, you may proceed.
May it please the court?
Yes.
My name is Kyle Benda. I'm an assistant county attorney for Hernando County, and I'm here on behalf of the appellant. Today's appeal turns on the answer to a single question, and it's whether the order titled Order on Complaint for Declaratory and Injunctive Relief and Petition for Writ of Certiorari entered by the trial court was a final order. If that order was not a final order, then the county's motion for attorney's fees was timely filed pursuant to Rule 1.525 of the Florida Rules of Civil Procedure, and then the trial court erred when it denied the motion for attorney's fees based on it being untimely filed, which would be more than 30 days after the order on the complaint. And also the subsequent order denying rehearing would also be error.
Did the county act as if this was a final order? Did the county do anything subsequent to the entry of that order?
Neither of the parties
I'm not
did
asking about
any.
the other party.
I'm sorry?
I'm not asking about the other side. I'm asking about the county.
The order on complaint was entered, and then the records were allowed for inspection, and then after the records were, or after those records were produced and inspected, nothing happened in the case, which is why the court entered its motion and notice of lack of prosecution. So
Okay.
the answer to your question is no, nothing was done until the court almost dismissed the case, which is what triggered the county to file its motion for attorney's fees to try and complete the case.
Does it matter that the rule uses, and I'm talking about Rule 1525, it uses the term judgment and not order? Is that a distinction without a difference, or does it matter here? We have an order here.
Yes, Your Honor, and I think it does matter. If you look at the cases cited by counsel for the Fair Association, I think the Saya case, I'm not sure if I'm saying that correctly, and the language of Rule 1.525 specifically say judgment. So an order is not a judgment. A judgment is a final order that completes all judicial labor in a case.
Was that argument made on appeal?
On appeal?
Yes, sir. The argument in response to my question, was that argument advanced by the county?
Can you repeat your question?
Yes, and my initial question was, does it matter that the rule uses the term judgment versus order? And you've said it does. My question is, did the county advance that argument in its initial brief?
In the initial brief, the county did advance that argument in the interpretation that the order on complaint was a final order. So regarding needing not specific words to indicate that something is a judgment, but words indicating finality, like hereby enters a judgment and so forth. So I think the argument was made and discussed in both briefs about in the section of the initial brief where it talks about that there's more judicial labor to be completed, and myself and counsel for the Fair Association argued about specific words that need to be in an order for it to be a final judgment, and the traditional words are like go forth without day, right? But the case law, and that was expanded in the reply brief where the case law says other words of similar import like hereby enters a judgment.
How does an order differ from a judgment, if it does?
An order differs from a judgment because the judgment completes all judicial labor in a case. There's nothing left for the trial court to do, and then the trial court loses jurisdiction to do anything. An order is, like a temporary order. And I think I would almost look at the order on complaint as something as a temporary order pursuant to section 119.11, where it requires an immediate hearing to be set in.
Well, what do you make of it? I'm looking at the order. It says shall provide immediate access. It says the requested records are public records, and pursuant to the provisions of the statute, HCFA has an affirmative obligation to allow. And then it says HCFA shall provide. That sounds pretty definitive.
Yes, Your Honor, but that order doesn't resolve the county's count for declaratory relief, which is asking for the trial court to find that the Fair Association violated the Public Records Act. One, by failing to preserve certain records. So I think in the Fair Association's response to that order, it indicated that they lost records or they can't access certain records. So the county is seeking declaratory relief that there was a violation of the Public Records Act, as well as a violation of the obligation for the Fair Association to, quote, respond promptly to a records request and in good faith. And then that duty under 119 is also related to the attorney's fees issue and the discussion about an unlawful refusal then justifying an award of attorney's fees. So the attorney's fees issue is similar to the declaratory relief sought by the county to respond promptly and in good faith to a public records request. And if you look at the Promenade versus D'Iberville case, and this principle is echoed by a 5th DCA case, Barfield, the production of records in a Public Records Act case does not moot the issues of that action. So that would mean that simply producing records doesn't resolve the case or finally adjudicate it. We're talking about a violation of a Florida statute, ultimately for the purpose of getting public records. But I think there are...
But isn't that purported violation wrapped into the fee issue? I mean, why aren't those one and the same, which the court reserves on the request of attorney's fees?
I don't think they're one and the same because it's two separate statutory sections in Chapter 119, but so it's a little bit different analysis of whether a party is going to be entitled to attorney's fees versus whether the Fair Association violated its duty to respond promptly and in good faith. But both provisions are violations of Chapter 119. And the county is seeking declarations and is entitled to have those issues resolved by the trial court for the Fair Association's violations.
Do you get fees if there was a reasonable response? Would the HCFA get fees? Or excuse me, would the county get fees if there was a reasonable response?
So the language is not a reasonableness requirement. If you look, I think it's the Jacksonville Police and Fire Pension case, it's a Supreme Court case, and it talks about that entitlement to attorney's fees is not based on the reasonableness of the response. It's whether or not that response was justified under law. And if you look at the Promenade case again, it basically says, let me just it's on page 983 of that case. It says, delay in making public records available is permissible under very limited circumstances. A records custodian may delay production to determine whether the records exist. If the custodian believes that there's some kind of exemption to the Public Records Act, or if the requesting party fails to pay for those records. Any other reason to delay production of records is not justified under the Public Records Act. Therefore, it wouldn't be a justification to then avoid having to pay attorney's fees if someone files a lawsuit to compel production of records.
You need an unlawful refusal.
Right, and the unlawful refusal is the unjustified delay.
Which can't be determined absent an evidentiary hearing,
Correct, Your Honor.
which you never asked for after this temporary order, or this order.
We asked for a evidentiary hearing.
You said if we need one, we want to come back for one, but nobody ever tried to schedule an evidentiary hearing to determine whether there was in fact an unlawful refusal.
And that was the motion for attorney's fees that the county filed asking for an evidentiary hearing on that issue, to which the Fair Association responded and actually filed an affidavit with facts. So to the extent that an evidentiary hearing is required for the motion for attorney's fees, the county's position is that the parties essentially stipulated to the facts. But assuming for argument's sake that this court rules that an evidentiary hearing is required, I would request that this court essentially award or rule that appellate fees can be included in the trial court's order for attorney's fees if the trial court ultimately finds that there was an unlawful refusal. So not turning this proceeding into an evidentiary type hearing, but essentially including the relief that for the appellate attorney's fees as part of that trial court attorney's fees. And I think there are some more procedural issues that occurred in the interim between the scheduling of the hearing. So there was a count from the county for a petition for writ of mandamus, and the trial court held in its order denying motion for attorney's fees, and then in a footnote in the order denying rehearing, that the petition for writ of mandamus was impliedly denied because there was no reservation of jurisdiction in that order on complaint. But the trial court could not rule substantively in denying a petition for writ of mandamus without first issuing the alternative writ, which the alternative writ is what commences an action for the petition for writ of mandamus. And the Fair Association can't waive the court's obligation to issue that alternative writ. So if the court...
You got mandatory or compulsory injunctive relief as part of the order in this case, right?
Yes, Your Honor.
Is that relief different than what was asked for in the mandamus petition?
Practically, no.
So you got the same relief?
Yes, Your Honor. So if the relief sought in the mandamus action or the mandamus count is moot because the records were produced, that would still need to be resolved in an order that is entered procedurally in a correct manner. Otherwise, if the county states a sufficient cause of action for petition of writ of mandamus, it is entitled to have that cause of action heard. Or to be able to respond to the mootness issue if the court was intended on denying it. The court can't impliedly deny a petition for writ of mandamus based on mootness without the procedural mechanism occurring to give it that jurisdiction to do so. And then also related to the finality of that order on complaint is that the pleadings themselves were not closed. The notice, the action itself was not at issue to even for that September hearing to be a final hearing. And in that final hearing, if you look at the transcript that of the argument of the attorneys in that hearing, there were indications that there were disputed factual issues which would have to be resolved in a formal final evidentiary hearing, unless the parties could come to a stipulation. And there was no clear stipulation. There was certainly discussion between the parties in that hearing before the court of possibly stipulating to an order to resolve the issues in the case, but no stipulation was ever entered. Therefore, that hearing was not a final hearing. It did not lead to a final judgment or a final order that resolved all of the judicial labor in the case. Therefore, the county's motion for attorney's fees was timely filed, and the case does need to proceed to a final hearing on the issue of that declaratory relief count. And if you don't have any more questions, I'll
Reserve? Okay.
Yes, Your Honor. Thank you.
It is
Good morning,
officially-
judges.
It's officially good afternoon, so.
Good afternoon. I'm sorry. The clock has continued to run. My name is Joe Mason, McGee and Mason in Brooksville, and I'm here representing the appellee, the Hernando County Fair Association. At the hearing from which this proceeding has evolved, my client was served with a complaint on a Thursday afternoon. I was engaged on a Friday and appeared at the emergency hearing on a Monday. Going into that hearing, I had concluded, and my client didn't contest, that there were public records that needed to be produced. The delay had been caused by extenuating circumstances involving COVID, injuries, and illness to my client's staff, but we admitted that there was public records that were due to be disclosed.
You didn't admit that in a responsive pleading, did you?
There was no chance for a responsive pleading. We walked into court and said, "Judge, we're guilty," so to speak.
You've never filed an answer in this case on behalf.
There was never an answer filed. But we submitted to the jurisdiction of the court, admitted that the complaint was correct, that there were records to be produced. We waived the issuance of an alternative writ, not specifically, but by submitting to the jurisdiction of the court, we waived its issuance. The Florida Supreme Court, way back in 1909, I believe, in the Carter case, suggested that alternative writs could be waived. The county takes the position it could not be waived since 1.630 was adopted after the Carter case. Well, I'll refer the court to the case Bradenton versus State ex rel. Perry. It's a Florida Supreme Court case in 1935, 160 Southern 506. And in that case, the court didn't talk about waiver, but went through the process of how a writ of mandamus and an alternative writ were handled under the then law. It is an exact, almost verbatim recitation of what our process is today. Rule 1.630, when it was adopted, did nothing but remove 9.100 from the process of a trial court writ of mandamus. I don't know how it worked, but before 1.630, the trial court 9.100 was sort of shoehorned into the trial court process for the alternative writ and a writ. And so nothing in the substance of how the writ was handled was changed by 1.630. Therefore, the Carter case, where the Supreme Court sanctified waiver of a writ of mandamus, of an alternative writ, has not been changed. Now, how is that important? It's important because if the county argues that the alternative writ was not issued, and therefore there could be no issuance of an order or a judgment on the writ of mandamus. Well, if it's been waived, then the court's order, which granted everything the county asked for, I won't use the magic words, but it decided that the records were public and it required that be produced. That's declaratory relief, it's injunctive relief, and if mandamus was on the table, it's also mandamus relief. If mandamus was not on the table, the judge declined to issue the alternative writ, which is the judge's privilege. I point out, as I did in my brief, Judge, now Chief Justice Roberts' famous statement that if more is not necessary to decide, it is necessary not to decide more. The judge obviously, if mandamus is not on the table, obviously recognized that injunction could grant the same relief. The judge's order doesn't say this is the declaration, this is an injunction, this is a mandamus. It just said, well, they are public, make them available.
Does it matter that this was an order and not a judgment, given the language of the rule that references a judgment? Or
no, sir, it does not. I think the law is clear. Judgments do not require specific words. They require elements, but there are a plethora of cases that say that the title to a document does not determine whether it's a judgment or a final judgment or a non-final judgment. That's determined basically by the words at the end of that, and I'll acknowledge, as counsel said, one of the words that's used is go hence without day. However, if you look at the Cardillo case, the words ordered, well, Cardillo says done and ordered, is sufficient to invoke the finality of whatever you want to call that document. It invokes the finality of that judgment. In this order, the word that's used is ordered. One presumes that when you say ordered, it's a done deal. So this case with the word rule,
or at least the cases say this rule should be strictly construed. And there's a pretty steep downside here. I mean, if you don't file within 30 days, you lose the opportunity. You would agree with that, right?
I would agree with that, absolutely.
But if we are duty-bound to be strict in our construction of this rule, and the cases seem to say that, and the language says after filing the judgment, including a judgment of dismissal, you would agree that this was not titled a judgment or a judgment of dismissal, correct?
It was, no sir, it was not. It was titled Order on Complaint. Order on Complaint 4, and then it listed all three of the causes of action pleaded.
And the rule goes on, it says, or the service of a notice of voluntary dismissal, and you would agree we don't have a notice of voluntary dismissal here?
No sir, there was not.
Which judgment, again that word, or notice concludes the action as to that party? Well, we don't have a judgment concluding the action as to the party, do we?
I'm sorry, I didn't quite follow.
Yes, sir. At the very end of the rule, it says, which judgment or notice concludes the action as to that party? Do we have a judgment that concludes the action as to that party here?
I think it does, Your Honor. The order says records are final. It doesn't hedge. It says records are final. Make them available. Period. Directive, definitive, I think the word you used earlier. It's a definitive order. Whether it's injunction, whether it's mandamus, it's get the records to the county, which we admitted going in was our responsibility. The reservation for attorney's fees, the county argues that it has a right to a ruling on the violation of law. Well, the violation of whether the records law was violated relates solely to attorney's fees. If there was no violation of law, attorney's fees are not available. That's what the potential evidentiary hearing was reserved to determine. There were 30 days to request the evidentiary hearing. That was not done. And contrary to the county's...
Could you, is there a situation where you could have a violation of the law and not get fees?
There is a situation which might be invoked here if there is the trial court evidentiary hearing. The cases suggest that there are extenuating circumstances where a court can rule that a delay in the production of records was justified and not unlawful. It would be a violation, if you will, of not producing them instantly, but it would not be an unlawful violation that would justify fees. And
that's really my question. I didn't ask it very well, Mr. Mason. Can you have an unlawful violation, meaning you violate the statute, but not get fees, is my question, where it would be an unlawful failure to provide the records?
That is correct, Judge, with the caveat that if the court, after a hearing, determines that it was justified, a justified delay, then there would be no fee award. But that's an issue that...
Doesn't that prove their point then? I mean, you're saying that you could have a violation of the statute that doesn't necessitate fees, and their point is there are two different analysis trees there. There is a violation of the statute that may be separate and distinct from the fee analysis. I
absolutely agree with that, Judge. The only caveat that I've got to offer, that I need to offer, is that the violation of the statute and the order to produce was entered, 30 days passed, and the request for fees was not made. Therefore, the opportunity to obtain an order on whether it was a non-justified, therefore unlawful violation was passed. And I might point out, the county argues that it has a right to have an adjudication of each cause of action. That's not the case. County has a right to have a determination made on whether it's entitled to the relief requested, not a determination of every cause of action. They got the relief that they requested, a declaration that there were public records, and a command, I won't call it injunction or mandamus, a command to produce. It could be either injunction or mandamus. They don't have a right to a ruling on every cause of action. Going back to Chief Justice Roberts' comment that you should not decide that which you don't need. If you need only the two causes of action, injunction and declaration, to get to where the county has its relief, then it's appropriate for a court to exercise judicial restraint, which is a common refrain for a court, to not decide that which it doesn't have to decide.
Well, even if the court was going to deny the mandamus relief, aren't they entitled to have that denial? Instead of something implicitly denied, shouldn't the judge say, I'm not going to grant it, and not just ignore it? They did ask for it in a proper pleading.
Well, the judge chose not to issue the alternative writ.
So we have to assume that he denied it.
The fair waived the issuance of an alternative writ, so that was an issue that on waiver was before the trial court. If it was not waived, then the judge chose judicial restraint. All I need is declaration and injunction. The county would not be entitled to a ruling on all causes of action simply because they raised the issue, so long as they get the relief that they were requesting. They got every bit of relief.
Let me ask you another question. What starts the 30-day clock?
The issuance of a final order.
If this order was final, why did the judge, after 10 months, have to say, hey, file something or I'm going to dismiss this case? Doesn't that tell us that, at least in the judge's mind, the case was still pending?
Well, bear in mind we've got two different trial court judges. The case was transferred from the original trial court judge who held the hearing.
I'm not sure that matters. They're both
I don't
equal
think it
circuit
does,
judges.
but just as the point of information, and the judge, when he entered the order, reserved jurisdiction to determine fees. There would have been no need to reserve jurisdiction if the judge didn't consider that to be a final order. There would be nothing to reserve because we would be required to come back. As the judge entered the order, there was no requirement to come back unless somebody wanted to request fees.
Excuse me, I don't see reserves jurisdiction. I just see reserves. Just says the court reserves.
Well, I don't know what he's reserving if he's not reserving
I'm going to
jurisdiction.
get to that later. Couldn't that mean I'm going to get to that later? I mean, I agree. If it said reserves jurisdiction, the point may be a good one, but it doesn't say that. It says the court reserves on the request of attorney's fees.
The court reserved on the issue of fees, didn't reserve on anything else, on fees only. And then on...
Well, that's all the court overtly says. But back to Judge Harris's point, which is a good one. Why, if this is a final order, if this is everything, if this is a judgment under 1525, why did the court need to say we hadn't had any record activity in the case? I just don't know why a circuit judge, even if it's a different circuit judge, would say we haven't had any record activity on this case that's final. That would almost be nonsensical.
Well, it's not unusual for a case to have a final judgment and sit unclosed by the clerk. It shouldn't, but it happens. This was a case where final relief was granted. You can't get any more relief than a declaration that the records are public and a requirement to produce them. That is total relief. As a matter of fact, at the hearing, the county offered the trial judge the opportunity to do one of two things. Either give full relief or we go to a final hearing, to an evidentiary hearing. The Fair Association didn't object to giving full relief. The judge chose to accept the alternative offered by the county to give full relief. They are public, produce them. That's all in the world the county ever asked for. They got everything, and they could have asked for fees, and I would have had no argument that an evidentiary hearing would have been necessary if they'd asked for fees within 30 days of that order. It's simply a 1.525 issue that they waited 30 days. There's no special privilege granted to the county on waiting past 30 days. The alternative writ was waived. Therefore, our position is that mandamus was before the court, as was injunction and declaration.
Where is mandamus in this order?
Pardon me?
Where is the word mandamus in this order?
There is not. The word declaration and the word injunction and the word mandamus are all missing. The court entered an order which could be granted under both injunction and mandamus. I I guess you could say take your pick. If waiver was effective, if waiver was not effective, it's obviously injunction. And the court is not required to specify, I'm granting relief under XYZ cause of action. It would be better to do that, but all the trial court is required to do is say, I'm granting relief. We firmly believe that the trial court issued an order on full relief. We firmly believe that the county's offer to the trial court to either issue full relief based on arguments of the parties and the stipulation that we made that it was a public record that needed to be produced. The court chose to go to full final relief rather than say, let's go to an evidentiary hearing. Trial court said, we'll go to an evidentiary hearing
Wouldn't the
only
final
to
relief have
determine
to
whether
include whether the records were unlawfully retained? Isn't that part of the final relief? The judge would have to make that decision.
only with regard to attorney's fees. Okay. It's inherent that the judge found there was a delay. It is not inherent that there was a determination the delay was unlawful.
But that's an issue the county raised in its pleading that the judge never resolved.
But it's an issue that's resolved only upon an attorney's fee matter. Whether there was a delay and whether that delay was unlawful is not an element of whether the records are public and whether they are required to be produced. The only element of whether they are public is whether they are in the possession of and generated by a public agency, and the only element of whether they are to be produced is were they requested and do they exist. And we admitted they existed, we specified what they existed, they were produced, and in point of fact, a determination of whether they happened to be, the delay happened to be violative, unlawfully violative, is an attorney's fee issue, where we would argue it was unlawful, the county would argue, we would argue it was justified because of extenuating circumstances. So we believe that the trial court granted everything the county wanted. Could the trial court have written an order that was more easily discussed and interpreted? Perhaps, but unfortunately we have the order that we have, but the relief was granted. The court directed that they were public. The court directed they be disclosed. No further relief could be granted. We got a final order.
Mr. Mason, your time has expired.
Thank you, judges.
I just want to try and address some of the questions that this panel has posed in this appeal. The first issue with, I think, Judge Jay's question about can you have an unlawful refusal that doesn't result in attorney's fees? I think no, because the unlawful refusal is basically a violation of the Chapter 119, some provision of it. So, for example,
doesn't that make their point then? I mean, isn't that their whole point, that they're baked into one another? So the reserving on the fees was nothing more than a reserving on fees, and everything else was taken care of.
No, and I think if you look at the transcript from the hearing, to try and maybe figure out what the trial court judge was intending with this order, the county proposed some different alternatives maybe for how the court wanted to conduct the hearing, based on some things that happened when counsel for the Fair Association came on. But one of the proposals from the county was basically for the court to enter a temporary order and then reserve on everything else. Temporary order to allow access to get the records, reserve on everything else for a later formal evidentiary hearing. And I think that's what the trial court judge did with its order on complaint. As far as I just want to make sure I get the site correct. It would be page 120 of the record, where those proposals were kind of floated, I guess, to the trial court judge. And I think that the trial court judge in that order entered what I would consider a temporary order, not a final judgment, and reserved on all these other issues later, just to get the records produced pursuant to section 119.11. The mandamus, even though the order itself says order on complaint for injunctive and declaratory relief and petition for writ of mandamus, the title of an order doesn't matter. It's the finality, the effect of that order. But the county only noticed, because it could only notice, the counts for declaratory and injunctive relief. It couldn't notice the petition for writ of mandamus for hearing because there was no alternative writ issued. So because it wasn't noticed, it's a violation of due process to even consider the petition for writ of mandamus in that hearing, in that September hearing where the judge entered the order on the order that we're talking about, whether it's final or not. The procedure of Chapter 119 is once a request comes in, the agency has to respond, quote, promptly and in good faith. Just that it got the record, that it got the request, that it's looking for the records, that they exist or not. And the next step is to assert specifically any exemptions that apply. And then once all of that occurs, the records are to be produced after a fee is paid. The only justified delays in that process are locating the records, paying the fees, as outlined in the Promenade case. The issues presented in the Fair Association's property manager's affidavit that his wife, who's the president of the Fair Association, had a severe case of COVID, that he had a knee injury, that they were going back and forth to doctor's appointments. That's not a justification under Chapter 119 to fail to provide public records. So if I made a public records request to Governor DeSantis and he said, oh no, I've got all these doctor's appointments, I'm going to wait 3 months and not even acknowledge your request, that would still be a violation, and I don't think any court would find that as a justified delay. So I think that the same analysis applies here. Thank you, Your Honor.
All right, thank you. It's well argued, and we will stand in recess.
All rise.